This is Michael Popok. You're on the new Legal AF YouTube channel, and I'm at the intersection breaking down for you that Donald Trump's not making idle threats to jail his political enemies. And we'll use as an example Michael Cohen, who just suffered a loss at the United States Supreme Court, the alt-right MAGA United States Supreme Court, who are not going to allow him to sue Donald Trump for tossing him back into prison after he had been released. Michael Cohen had been released because of his health issues and during COVID times. Donald Trump, because he didn't like what Michael Cohen was saying about him on social media, in podcasts, and in books, in a violation of Michael Cohen's First Amendment rights, had the Bureau of Prisons toss him back into prison, and not just return him into prison to try to finish out his sentence, but also put him into solitary confinement for 16 days. Now, this was so bad at the time that senior federal judge Alvin Hellerstein, in ordering the release in a writ of habeas corpus / mandamus type action, in ordering the release of Michael Cohen, found that Donald Trump had retaliated against him and ordered his immediate release back to home confinement. Why are we at the Supreme Court? Because Michael Cohen will not rest until he gets justice. Now, the door has finally been shut and the gate has been closed on him. But what he was arguing was for a very, very difficult cause of action that a person can try to bring against a federal officer, in this case, Donald Trump and others, Donald Trump and the members of the Bureau of Prisons, under what's called a Bivens action, Bivens, named after a case from many, many years ago. The problem is if you're bringing a Bivens action, then you have to get over the hurdle that in the last 30, 40 years, including just 2 years ago, the United States Supreme Court has narrowed almost out of existence the attempt to bring a case against a federal officer doing arguably their duty or within the scope of their work. It's an immunity. We're back to immunity again, but it's an immunity of a federal officer to not be sued civilly as opposed to criminal immunity for their actions, even if it's outside the scope of their authority. And ever since the Bivens case for the 1970s, in which the old Bureau of Narcotics agent was sued, the Supreme Court doesn't really allow Bivens actions anymore. In fact, there was a recent case in 2022, Egbert versus Boulay, that has been cited dozens and dozens of times by lower federal courts to stand for the proposition that it's almost impossible to sue and get through civil immunity in order to sue under this United States Supreme Court precedent. Recently, in the Egbert case by the Supreme Court, a Border Patrol officer was not able to be sued. Now, Donald Trump also argued in his brief, signed by one Alina Habba of all people, that he also had presidential immunity and he couldn't be sued civilly for this particular set of actions. Again, Michael Cohen claiming that his civil rights were violated, his First Amendment rights were violated, his Fourth Amendment rights constitutionally against illegal searches and seizure. That because of presidential immunity, he couldn't be sued. Now, the Supreme Court did in a one-line order. We had to find it, look very carefully in the orders that were just listed. Just denied the appeal without any commentary or any opinion. Michael was appealing from the Second Circuit Court of Appeals in New York that had ruled against him and had found that he could not maintain a Bivens actions. There might have been a couple of other ways creatively to get around that, including another type of constitutional civil rights violation. But the way that Michael's team of lawyers brought it, the Second Circuit believed they had no other choice, given the 2022 decision that I just outlined in Egbert versus Boulay, to dismiss Michael Cohen's claims, hence the need to try to take an appeal, which the Supreme Court is not going to agree to hear, which means the Second Circuit ruling against Michael Cohen, finding that he cannot maintain a case against Donald Trump or against the Bureau of Prisons for the 16 days that he was retaliated against and thrown back into prison, will remain. It's a very interesting case. You know, Michael, when he gets in front of some federal judges like Judge Hellerstein, they side with Michael and they find that Trump clearly retaliated against their former fixer. Other federal judges, frankly, have sided against Michael Cohen. Although Michael was one of the star witnesses for the Manhattan DA's office in their successful 34-count felony conviction against Donald Trump and others for business record fraud and election interference related to the Stormy Daniels hush money cover-up. He testified for 2 or 3 days. Now, let's just back up so everybody gets on the same page about how we got here. Michael Cohen, before he became a successful podcaster and book writer and on the Midas Touch Network, and somebody that I know pretty well, he had been Donald Trump's inside guy, his consigliere. He was a scary guy when he worked for Donald Trump. There's no two ways about it. Boris Epshteyn, who's been indicted in Arizona, has replaced Michael Cohen in the inner circle as the consigliere. But Michael held a lot of power and a lot of sway. He thought he was going to be in the cabinet when Donald Trump went to the White House, and was instrumental in arranging most of the dirty works and dirty tricks for Donald Trump in his private life, and covering up for him. He pled guilty to several counts of felonies related to taxes of his own, and related to election interference and those types of things. All, most of it related to the work done for Donald Trump. And he was sentenced in 2018 or so to 3 years in prison as a result. Now, then fast forward, COVID hit. Michael has health issues that are well documented that would be exacerbated. COVID could have killed him, and he was able to get out as they were releasing many people out of the jails during COVID to kind of get people further away from each other to stop the spread of COVID within confined areas like prisons. And Michael was released to home confinement in Manhattan until he started chatting away and using his First Amendment rights, social commentary, political commentary. This is before he joined the Midas Touch Network. And then the Bureau of Prisons and the Parole Board, Probation Board contacted him and said, yeah, you can stay out, but you got to sign this non-disclosure agreement. I got to tell you, in all my years of practice, decades and decades of practice, I've never heard of a Bureau of Prisons pulling out what amounts to a private party non-disclosure agreement and gag order and requiring him to sign it as a condition of staying out. That came from Donald Trump. That's Donald Trump saying, shut Michael Cohen the F up, or put him back into solitary confinement. And Michael courageously would not sign that NDA, and they threw him not only back, they ordered his return and surrender back at the prison and leave his home confinement despite his health conditions. But they threw him into solitary confinement for 16 days. And that is the basis of the retaliation, civil rights, constitutional claim that Michael has brought. And that's where the immunity block went up. I guess we should say we're fortunate that the Supreme Court didn't want to touch Alina Habba's argument that presidential immunity applied to this, to have another court expounding on presidential immunity again. I guess we didn't need that. But it's not a great day for Michael Cohen, and it's not a great day for our society, as we have the guy running for president has publicly threatened to jail his political enemies, U.S. citizens that are political enemies, that he calls U.S. citizens and voters. He calls them the enemy within. And the Republicans, somehow get away with saying that the Democrats and Kamala Harris are the ones that are divisive. I don't know. I never heard Kamala Harris say that people should be jailed. Other Americans should be jailed. But Donald Trump has threatened to use the National Guard and the U.S. military against American citizens. He said it out loud. More than once, in an interview with Maria Bartiromo on Fox, in rallies. If he's not saying it, J.D. Vance is saying it, or his surrogates like Kash Patel, who could be the head of the CIA, who said, day one, we're going to be jailing members of the media and it's almost like Catch Me If You Can, members of the media and our political opponents. And if you want to have a textbook of example of Donald Trump doing that, it's Michael Cohen. And look what the Supreme Court has done. Absolutely nothing to serve as a firewall to protect the outlandish, violent, fascist tendencies, dictator tendencies of Donald Trump. He's now unshackled, right? It's the Frankenstein monster. It's the Frankenstein monster loose in the countryside. With the country town people, what do you call it? The local people, there with torches and pitchforks hoping to control him. But the Supreme Court has taken away the torches and the pitchforks and let the monster just run wild. And because every time Donald Trump hears he wins another case at the United States Supreme Court, he translates that into, I can literally get away with anything and they won't stop me. And this is another example. I mean, they could have set things right, the United States Supreme Court, and said, you know what? Donald Trump was a little bit out of control there. They should not have required Michael Cohen to sign, as a condition of his continued release, a non-disclosure agreement against him. And it looked like, and it was, Donald Trump jailing, returning to jail his political enemy and putting him in solitary confinement as a punishment. And there should be a cause of action for that, for the redress of civil liberties. Usually it's like a 1985 action under Title 18, but for some reason that's not the way they went. They went this Bivens route, which I think was a difficult route, a difficult needle to thread, and especially given the more recent rulings that have just basically killed every type of civil rights-oriented lawsuit, like the one that Michael brought, has just died since the Supreme Court killed them all with this decision in 2022, Egbert. So we'll continue to follow it. I've asked Michael to come on and be interviewed here on Legal AF by me. I'm hoping he'll take me up on my offer. And if so, you'll be the first to know, the second to know, right here on the new Legal AF YouTube channel. Here's your chance. We hit 250,000 about 2 weeks earlier than I thought. Now we're heading for 300,000 and hopefully 500,000 by the time of the new year. And that's a testament to you, people that are helping us grow this pro-democracy channel one brick at a time with our bare hands. I'm curating it, sure. I'm bringing you the content that I hope you enjoy, and the numbers say you do. We got over 12 million views in 35 days. It's almost unheard of. We're doing this, of course, in collaboration with the Midas Touch Network, but you being here matters, and you getting other people here matters. So it's early voting time. Hit the subscribe button. It's free, and bring others along with you and do the same thing. So until my next Legal AF podcast, my next content here on Legal AF, the channel, I'm Michael Popok, and I am reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.